one of the main purposes was to change the business processes of the land sector agencies. And one of the problems that we identified in implementing the land reforms was the absence of clear demarcations of the boundaries of large landowners.
Okay.
So let's take Accra. There are big blocks of groups that constitute the large landowners in Accra. So you have Nungwa, you have La, you have Teshi, you have Jamestown, you have Sempe, you have Asren, you have Bese, Kolewe, you have all of these groups that are landowners. There are stool and entities that own land adjoining the coast. So Nungwa, Teshi, La, Osu, Jamestown, they all are coastal groups, but they have land in the hinterlands. So the boundaries of these large owners presented some very unique problems. If you move out of Accra, the coast, you go to Pantan, Damfa, that area, it's Teshi land. Teshi land will be sharing a boundary with La land. There is a place called Amahia on your way to Dodua. That's La. Oyarifa is La. Adenta. So one of the challenges we encountered was how do you determine these people, their boundaries, these groups? Historically, they knew where the boundaries were. But because land had become a serious economic issue, these groups started not telling us the truth about their boundaries. We needed to get all of them. We implemented a program under the LAP called Systematic Boundary Demarcation, where we had funds available to go and demarcate the boundaries of the large owners across the country. But how do you get the La people and the Osu people and the Teshi people all on the ground so that you can identify and demarcate and pillar their boundaries? You call the meetings, nobody shows up. When they show up, there are fights, fist fights. I remember a meeting at the Institute of Local Government Studies in Medina. Fights, blows between the traditional landowners. So that part of the project, we couldn't make as much progress as we thought. If we had made significant projects in that area, it could have taken out some of the multiple sales, which are the results of indeterminate boundaries of these large landowners. There are some deliberate sales that are fraud, but there are instances where there are conflicting transactions because of the indeterminate nature of the boundaries. So we sought to, like I said, change the way these agencies do business. So for example, if you go to the land title registry, there were about 29 steps you have to take at the land title registry to register your land. Now, under the new system, those steps have been shortened because there were serious reviews of the business processes, and we found out that there were certain processes that have been put in the stream which we could ignore, we could take out and still achieve our objectives. You see, so something it's not, and my colleague talked about the Land Use and Planning and Special Planning Act. Previously, you had the Town and Country Planning Department, and the Town and Country Planning Department at the decentralized level was reporting to Ministry of Local Government. At the national level, they were reporting to the Ministry of Environment, Science and Innovation also. Now, part of the LAP, and most people may not know, but one of the major outcomes of the LAP was the passage of the Land Use and Special Planning Act, which now has created a new authority to be responsible for special planning. Okay. And this new legislation, Act 1036 of 2020, has for the first time provided an interface between land registration and planning. In the past, register your land, we plan our development. Now, the land registrar has an obligation to ensure that before the land is registered, there should be consistency with planning, as approved by the planning authority.
Now that you're already talking about this law, give us your brief overview of the law.
This piece of legislation, the Land Act 2020 Act 1036, for me is a very important event that has happened. And this event is a very long journey that started in 2003. And for most of the people who have been around the lap, on the 23rd of July, when Parliament passed this bill into law, it was a day of excitement. The reason I am saying this is that the bill, which has now become law, assented to by the President, has introduced at least 30 reforms into the land sector. At least 30 things have changed from this bill. And if I give you an overview, the first thing that has changed is that for the first time, we have clarity on the structure of interest in land recognized in this country. So if you take the law, Section 1 sets out clearly what the interest in land, and when I say interest in land, I mean the legal relationship you have with the land. Because something we discourage the use of the word landowner.
That's right.
Because of the possibilities of confusion. Because land lends itself to multiple ownership at the same time. So if there's somebody could have the allodial title and create a freehold out of it, and a lesser, a subordinate interest like a leasehold, a sublease, a license, you can create different strata of interest out of the same parcel of land. So we normally would say interest in land, meaning if in respect of a particular parcel of land, what is your relationship? What can you do with the land? Are you a freeholder? Are you a leaseholder? Are you the holder of the allodial title? And what are the bundle of rights that you can assert in relation to a parcel of land? So for the first time, we have legislation which has set out clearly that in this country, the recognized interests are, and they are listed. So if you go to Section 1, it starts from the allodial title and talks about customary law freehold, common law freehold, usufruct, leasehold, and customary tenancies. What else we have done with this law is to now clearly set out the distinction between the freehold, either common law freehold or customary law freehold, and the usufruct. Because in the previous legislations we had, the word common law freehold, the term common law freehold, customary law freehold, freehold were used interchangeably and created some confusion. Now, we say clearly in this law that either you have the allodial title or you have a common law freehold, you have a customary law freehold, you have a usufruct, you have a lease, or you have a customary tenancy. So the interests in land are now clear. We also...
I know there's a difficulty in translating the various terminologies because you can't discuss land without using these terminologies, allodial, freehold, usufruct, and the rest of them. But can you spend a minute and try and help those of us who don't know what this means?
So the highest interest that you can have in land in this country is the allodial interest. The allodial interest is coming from a German word allod, which means the totality, the all. So if you put the land interest in a structure like this, in a pyramidal structure, the allodial title sits at the apex of the pyramid. It means it is that interest in land which gives the most extensive incidence or rights to the holder.
And normally, those who will have the allodial title will be who?
Normally, the allodial title could be vested in a stool, or the allodial title could be vested in families. So in some parts of the country, so if you go to like some areas of Accra, Jamestown,
right,
there are cases, Jamestown stool and Sempe stool, which say that the allodial title could be vested in a head stool,
right,
or in a sub stool.
Right.
If you go to the Ashanti region, there is the case of Yabo and Ababio, the case involving the Kasi stool, which says that the allodial title was vested in the Kasi stool. Now, in some cases, the allodial title is vested in families. So if you go towards the Dangbe areas, Ningo, Pram, and in fact, some of the Akwapim areas, the allodial title is vested in families.
Right. And
there are cases like Amioda and Podia on the Ningo side.
So
now, if you go up north, for example, there are cases where the allodial title is vested in stools, like in Azantilo and Nairi. And then where the allodial title is vested in Tindanes, like in the Boliga areas and so on. And in some cases, the allodial title is vested in clans, like in the Adan areas.
Right.
Or it is even possible, there's a case called Nyasemwe and Amphibiasan, which says it is possible for the allodial title to be vested in an individual.
Okay.
So it's...
Yes, so now let's proceed to the common law freehold and the customary freehold after the allodial, which maybe the commonest way to not forget the allodial is that he says is the one that sits at the apex, and you can say is sort of the original owner, so to speak. Okay.
It's the title that could have been acquired through discovery and occupation of terra nullus, which is land which has not been occupied before, or it could be acquired through a secondary mode by way of a conquest.
Right.
So the conquered group, they will lose their land.
Yeah. Okay. All right, so let's go to the next one.
The customary law freehold is a freehold interest, which means that the interest you are talking about is of indefinite duration, and it is potentially perpetual.
Okay.
So a freehold would run from a date, and it will run indefinitely until some event which will truncate the freehold interest occurs. In the case law, it could be denying the title of the allodial holder, or dying without successors, or the state intervening through the exercise of the power of eminent domain, compulsory acquisition, or vesting, so to speak.
Okay.
But under the system that we have, the freehold interest, the customary law freehold, the common law freehold, the usufruct, it is not possible for me to sit here and say that they've been arranged in a hierarchical order.
Okay.
Because the customary law freehold, the common law freehold, and the usufruct should be at par.
So the one that I get up as an individual or a company, I'm going to the stool to take, and I'm asking them to give me this parcel of land. I pay money, they do an indenture for me, and I take, and I'm going to Lands Commission. That one is what?
Most of the time, it is a leasehold.
Leasehold?
Yes.
For a maximum?
For a definite duration, or a duration that is capable of being made definite.
Right.
And it is subject to certain terms and conditions. Now, the most interesting thing about the leasehold, and especially because it's been put in Section 1, The Supreme Court has said in this country, in the case of Nana Bedi Akwatre and Osei-Wusu, that leases are not indigenous to our customary law. So it means leases are a creation of colonization from the common law. But now we have adopted the leasehold concept.
Okay.